Students at the back row, please shift forward quickly. Yes, there. Please occupy these chairs. Yes, if you want extra attendance, please shift forward. Yes, especially last two rows. Yes, I want to see all these front chairs to be filled. Please, quickly. Yes. Front rows, please. Sneha, shift forward. Yes, please occupy the front rows. Quickly. So can I start? Okay. Good morning, everyone. Before we commence this guest lecture, I would like to share a brief biography of our guest. Advocate Anil Malhotra is a practicing advocate based in Chandigarh, India. He attained Bachelor of Science and Bachelor of Laws degrees from Punjab University, Chandigarh, and LLM degree from the University of London in 1985. He studied comparative family law at London School of Economics and law and society at School of Oriental and African Studies. For over 37 years, he has continued to act as an expert and as amicus curiae on Indian family law in foreign courts on appointment by the bench in overseas jurisdictions. He has co-authored 9 books titled Acting for Non-Resident Indian Clients, India, NRIs and the Law, Indians, NRIs and the Law, Surrogacy in India, a Law in the Making, International Indians and the Law, Surrogacy in India, a Law in the Making Revisited, India, Inter-Country Parental Child Removal and the Law, The Removed Child and the Law in India, and the Global Indians and the Law. He has significant published work and has both international and domestic conference participations, besides over 1,000 newspaper columns to his credit. He is a fellow of the International Academy of Family Law and an India Representative Family Law Committee, International Law Association, London. He has expertise in rendering expert reports to foreign courts on surrogacy, inter-country adoptions, nationality, citizenship, marriage, divorce, maintenance, and succession involving global Indians or foreigners. An amicus curiae, his report on inter-country parental child removal is part of a Punjab and Haryana High Court judgment referring to the Law Commission of India, recommending that India consider signing the Hague Convention. Further, he has served as a member of the Committee of Ministry of Women and Child Development, Government of India, to examine legal issues involved in resolving problems of parents and children involved in issues relating to interparental or inter-country child removal, whose report was submitted to Government of India on 21st April 2018. He regularly lectures as a resource person at institutions like the National Judicial Academy Bhopal, Chandigarh Judicial Academy, national universities across the country, and of course, Symbiosis Law School, Pune. Today, he would be delivering his lecture on the topic Emerging Issues in Family Law. Now, I heartily welcome you to the dais.
We today have two very interesting topics, very current, very alive, and very full of meaning. And both of them are slowly getting correlated. So we are going to spend time first looking at domestic violence, and then we will look at live-in relationships. I'm going to keep at least 45 minutes for questions. So please listen carefully and feel free to ask any question. Don't be embarrassed, out of perspective, in perspective, feel free. Now, before we go into both the topics, can anybody tell me what the preamble to the Constitution says? Anybody? Anybody? Yes. Wonderful. Please stand up. Just rattle it off. I can't hear you. So what we will do, we will promote you to the front seat. No, no, we want to see. I want to see you all the time. No? I can't see you. Do I stand up to see you, or you are coming in front? There are three seats there. Sir has vacated one seat. Sir is going to get the sofa seat. Sir, you have been elevated. Okay. We, the people of oh, क्या बात है. Marvelous. That's it. If I was you, I would have given you a medal straight away. See, the preamble to the Constitution is the life of the Constitution. For the present context, it says that we are a sovereign, socialist, secular, democratic republic, and we have liberty of thought, expression, belief, faith, and worship, equality of status and opportunity. Now, let us jump to the Domestic Violence Act. Now, anybody knowing the preamble to the DV Act? Any other bright child? Doesn't matter. So the Domestic Violence Act, which we have enacted, came because we became a party to the convention called CEDAW. CEDAW was the United Nations Committee on Convention of all forms of discrimination against women. So it is an act for effective protection of rights of women guaranteed under the Constitution who are victims of violence of any kind occurring in the family and from matters connected thereto. I pause. In the Constitution, we are talking of equality of law and equal protection laws. We are talking of equality of status and opportunity. We are talking of justice, social, economic, and political. The question which I pose to myself is, why have we made a law for protection of women from domestic violence? Why is it not protection of persons from domestic violence? Why not men? Why not transgenders? Why? This occurred to me today. We may have signed the CEDAW, but we are still free to tweak the law and make our law to what we think we want to do. Just a thought. Keep it in your mind, because the law is to be equal. We are saying men and women are equal. We are providing equal opportunity. So why not equal justice? Now, this is a provision. This is a law which has three very important definitions. So to start with, there is a definition of an agreed person. Who is an agreed person? An agreed person means a woman. I pause here. Two things. Aggrieved person has to be a woman. An aggrieved person does not have to be a anybody does not have to be a wife. So this means that the DV Act travels to relationships in the nature of marriage. We have brought in live-ins through the back door. Now, if you were to invoke the provisions of Section 498A of the IPC, does anybody know what is 498 of IPC? Absolutely. So, if I want to invoke matrimonial cruelty in a marriage, I will go under 498A. So, there the occurrence of a marriage is a prerequisite to seeking the benefit of registration of a criminal case for matrimonial cruelty. Now, in today's times, registering a criminal case for matrimonial cruelty, I think is outdated, is colonial, and it should become a civil remedy. Because the misuse of that law to rope in the whole family for matrimonial cruelty and Section 3 and 4 of the Dowry Prohibition Act is a way of putting the whole family in trouble. So that apart, so having realized that little fine imprint, so we are talking of a woman who has been in a domestic relationship, is not a marriage, with the respondent who alleges to have been subjected to any acts of domestic violence by the respondent. So there are two keywords here. One is the respondent. So the respondent is the one from whom the aggrieved person wants relief. And both of them are in a domestic relationship. Now, who is the respondent? Respondent is an adult person who is or has been in a domestic relationship with the agreed person and against whom the aggrieved person has sought any relief. Now, further proviso reads, provided that an aggrieved wife or female, now this is where they bring it in, living in a relationship in the nature of marriage may also file a complaint against the relative of the husband or the male partners or the male partner. So husband, his family can all be roped in, even in a case where they are in a relationship in the nature of marriage. Now, the parliament has been very careful. They have not intentionally used the word live-in relationships. But I think by using a phrase relationship in the nature of marriage, they have perhaps enlarged the scope and they have perhaps given it more import. So, second part, what is a domestic relationship? So, a domestic relationship means a relationship between two persons. Now, it's two persons. Now, I don't know if this can be extended to two female persons. It can't be two male persons because the agreed person has to be a female. So it's a relationship between two persons who live or have at any point of time lived together in a shared household where when they are related by consanguinity, marriage, or a relationship in the nature of marriage, comma, adoption or family members living together as a joint family. So this is the second time the phrase of living in a relationship in the nature of marriage is used. So two people, married or unmarried, in a relationship is enough to give you the title or benefit of an aggrieved person against a respondent in a domestic relationship. Now, from this, we jump to what is a shared household. Shared households means household where now I don't understand why the word person is used here. Why is it not woman? When the aggrieved person is a woman, why say person? It's an interplay which will cause problems somewhere, with some upstart coming somewhere and seeking relationship, maybe in a same-sex relationship. So anyway, that apart, means a shared household means a household where the person aggrieved lives or at any stage has lived in a domestic relationship, either singly or along with the respondent, and includes such a household, whether owned or tenanted, either jointly by the agreed person and the respondent, or owned and tenanted by them in respect of which either of the agreed person or the respondent, or both singly and jointly, have any right, life, interest, equity, or includes a household which belongs to the joint family of the respondent, of which the respondent is a member, irrespective of whether the respondent or the agreed person has any right, title, interest, or share or household. Now, this definition brings any building, any joint family property, or any and everything into it. But Supreme Court watered it down. It said, if if the parents or other family members own the property and live in the property, and the aggrieved person has not lived in that property, then she cannot have the right to that shared household. So, with these definitions, what the Supreme Court has done in the first judgment which came in D. Veluswamy, this is 2010 Supreme Court judgment. Now, in Veluswamy, they broadly laid down relationship in the nature of marriage is akin to a common law marriage. But the couple should hold out themselves together as spouses akin to a marriage. They must be of legal age to marry. They must be qualified to enter into a legal marriage, including being unmarried. So yesterday we talked about somebody being married and having, so that doesn't work. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses. So basically, what is actual is you should qualify all conditions for being married, and you have not married. Now, all live-in relationships will therefore not qualify for protection under the DV Act, because the barometer is you should satisfy the conditions of marriage. Now, all this is said by the court in Veluswamy's case by watering down the judgment. Then, in the context of domestic violence, it is also clear that the aggrieved wife or female in a live-in relationship will file a complaint not only against the husband, but also against his relatives who are living in the same property along with him. Now, Supreme Court has also in Tarun Batra's case watered down the shared household. Now, there they have said that the wife is not entitled to live in the house owned by the husband's mother. House owned by the mother of the husband does not come within the details of a shared household. The Supreme Court has again watered this down in the opposite side by giving limited rights access there also. These are the key definitions of the Domestic Violence Act. Now, what is most interesting is the procedure and the court before which all this goes. Now, this application which you will make for a domestic violence, it goes to a magistrate. Now, a magistrate means a judicial magistrate of first class exercising the jurisdiction under the CRPC, where the aggrieved person resides temporarily or otherwise and is living when domestic violence is suffered. Or if you go to section 27, it also goes to a place where the aggrieved person has moved to. I have handled cases where women have suffered domestic violence in Cape Town, but the complaint is filed in Delhi. The court says, let us read section 27. And I had no words. 27, if you read 27, 27 says, the code of the judicial magistrate, as the case may be, as the case may be, the code of the judicial magistrate, as the case may be, is within the local limits of which the person aggrieved permanently or temporarily resides or carries on business. The respondent resides or carries on business, or the cause of action is arisen. So the person aggrieved permanently or temporarily resides where the respondent resides, that is, of course, the husband or the partner, and where the cause of action is. The most dangerous is the first one. So you are living abroad You have a bad marriage. There is no domestic violence. You come to Delhi, Calcutta, wherever you live, temporarily, you can file a complaint. Now, the question which I have put to the court when I have dealt with such a matter is, then why is the provision of Section 1 regarding application of the Act limited to the whole of India? For domestic violence suffered in England, Canada, America, Australia, how on earth would the Indian domestic violence? So there is clearly a wrong slant. Maybe somebody will channel the worries and seek setting aside. So we we have seen section 3, matrimonial cruelty we've seen. Now let us come to section 12. Now, the magistrate at the lowest level is the man who's handling or who is going to take on the application. Now, an aggrieved person under section 12 will make an application to the magistrate, and the magistrate on the first date of hearing, which will not be which will not be more than 3 days from the date of the receipt of the complaint, he will hear the matter and endeavor to dispose it off within a period of 60 days of the first hearing. Now, from practical experience, I have seen that the district magistrate who hears an application is a very junior level officer who is not very experienced, who has not been exposed. And if there is a smart pushing lawyer, he can get anything he wants in the first date. Mind you, under the Domestic Violence Act, you don't have to lead evidence, you just have to file an affidavit. It's a summary procedure. And without further ado, let us see what you can get. Now, under section 12, you can get one under section 17, right to reside in a shared household. 2, you can get a protection order, meaning you will help or your partner will be told to keep distance from you. You can get a residence order in a shared household. Next, you can monetary relief. You can get child custody. You can get compensation. And under section 23, which is probably the strongest weapon, is the power of the court to grant ex parte interim orders. So the magistrate can pass any order if he's satisfied that an application prima facie discloses domestic violence by an agreed person. So what is the degree and level of proof before a magistrate? Very, very faint. And it's one-sided. And whatever order is got on the first date prevails throughout the case, it is impossible to dislodge it. Heavily misused. If there's a bad marriage, you can use 498A, you can use DV Act, you can use 125. And by the way, under the DV Act, you are free to do anything else and all other remedies besides DV Act. So DV Act alone does not create a bar for any other law to be invoked. But then there is a bigger question. Suppose you get a child custody order under the Domestic Violence Act. I did a matter in Australia where that child custody order was produced before an Australian court by a lady saying, I have custody under the Domestic Violence Act. So I was asked to commission a report on whether a custody order under the DV Act is a proceeding for the custody of a child. The answer was no, because the proceedings for custody can only take court under the Family Courts Act and under the Guardian and Wards Act and the Family Courts Act. There is a procedure laid down. There has to be a pleading. There have to be issues. There has to be evidence, and then there has to be a decision. And there is a reported judgment in 2021 of Aman Loya versus Kiran Loya. I appeared in the Supreme Court for a gentleman who, after a bad marriage and being unsuccessful to get interim custody under the uh, Guardian and Wards Act in a guardianship petition, he escaped India via Bagdogra, Nepal, and went to Dubai, converted to Muslim religion, and took a citizenship of the Dominican Republic. So he ceased to be an Indian. He ceased to be a Hindu. But the Delhi High Court was livid. An FIR for kidnapping was registered against him. How and why, I don't know, but it happened. His family was hauled up for contempt. And a very senior lawyer was engaged in Supreme Court to appeal against these orders in the Supreme Court. And I was asked to assist in the family court matter. So the question was, did what he do was wrong? Yes, what he did was wrong. But did what the mother do after he fled, was it legally wrong or right? Now, they were in the family court. The day the husband absconded and the lawyer who represented him pleaded no instructions, the the mother moved an application for transposing herself as the petitioner and her husband, who had filed the guardianship petition, to be transposed as the respondent. This transposing application was allowed without notice because there was no counsel on the opposite side, and the matter was fixed for the next day. On the next day, the mother filed an application under Section 151 CPC, which is a remnant provision we use, and claimed custody. And can you believe it? The family court judge granted it. That family court judge of Delhi is the sitting judge of the Delhi High Court now. So we managed to file an appeal against this order of the court in the Delhi High Court. But Delhi High Court, nobody listened. They said, you are a contemner. We can't hear you. You have absconded. How can you invoke the jurisdiction's court? Anyway, the Supreme Court, in its wisdom, Justice Khanwelkar acted very wisely. Khanwelkar, Gawai, Murali, bench. I appeared online and they heard me for 20 days up to shutting the court totally after just 12 o'clock. So my contention before the Supreme Court was, can you cut short procedure? Can you abrogate substantive law? Can you jump over the procedure prescribed by statute? No. So if the claiming her rights, the court ought to have framed issues. The court ought to have had tangible evidence. The court ought to have given an ex parte decision on evidence. The court should have offered an opportunity of rebuttal, none appearing, evidence closed, and then the court should have pronounced judgment. My submission to the court was that if you are going to allow this, every family court will start becoming a court to no end, power keg, violate procedure. So this Supreme Court judgment in Kiran Lohia, Amal Lohia versus Kiran Lohia, is a landmark judgment on substantive procedure. So this is to bring home a point that a custody order under provision section 21 of the DV Act is not a substantive remedy or not child custody order, because the child custody order obtained by an ex parte order by a magistrate simply on the basis of affidavits without seeking the rebuttal of the opposite side is not a valid order. So this is actually the long and short of it. Section 17 gives you the right to live in a shared household. You can actually get any and everything on the first date. And once you are secure with this relief, be it a residence order, be it monetary relief, so you can actually carry on with all this. And section 26 of the DV Act says any relief available under section 18, 19, 20, 21, and 22. These are all protection orders, residence orders, custody orders, may also be sought in any legal proceeding before a civil court, family court, or a criminal court affecting the agreed person and the respondent, whether such proceeding was initiated before or commencement of the act. So it is a free handle to go as far as you can. So this is what broadly the Domestic Violence Act talks about. So before we get into the live-in relationships, I would leave the floor open for questions on the DV Act. I've given you enough food for thought. Now, please feel free to ask any question which comes to your mind and in which you think the DV Act is right or wrong. And if there is any input you would like to give to yes. Yeah, go on.
Sir, you said that when it comes to the
Yeah, go on.
so, sir, you said that when it comes to the DV Act,
Yeah.
the child custody order is not a valid or as valid as a proper and Wards Act. But, sir, then what exactly is the legal position regarding that?
See, number one, it is not a bar for the other parent to go to the guardian and wards judge and say, I want you to decide my interim custody in this petition, minus any order which the DV Act code has given to decide my rights. But at the same time, you are free to go back to the magistrate who has passed the ex parte interim custody order and say, I have filed a petition, or my petition before the